All right. Hello, everybody. Welcome to May's What's Up with Us. I'm Ashley Peterson. I'm one of your hosts today. I'm here with Frantz Farreau, my co-host, and our guest co-host of the day today, Pam Brown McGill.
Hey guys, happy to be here.
Thank you. Thank you. We also have our exciting interviewee guest today, which is Sanashi Kapoor. Thanks, Sanashi, for being here today.
I'm excited to be here. Thank you, Ashley.
Great. Well, we're missing Neil this month. Obviously, unfortunately, he was stuck in an arbitration, so he is not here, and I will do my best to fill his shoes while he's gone. But he will be back next month. So here's our agenda for today. We are going to talk about a couple hot topics. Since I'm in San Diego, there's been a couple new things that were enacted here in San Diego that are pretty relevant. So we're going to talk about the new short-term rental ordinance and the eviction moratorium for the county. Then we'll have our lovely interview with Snakshi. And then we have a couple of different cases to go through and some upcoming MCLE events. And that'll be it. So we got a lot to cover and we'll jump right in. Meant to remove JR's photo there. I'm sure Frantz was in the photo. I don't know what happened. That's not my fault. Oh, there it is. Okay. All right, good.
Nice.
All right. So, and obviously you all feel free to jump in when you have thoughts or ideas that you want to contribute here, but I'll kick it off with this short-term rental ordinance, since I've been speaking on short-term rental laws for quite some time and have been monitoring, throughout the state of California, what's being enacted, what's happening, where things are going. And so San Diego is pretty much the last major city in California to enact these short-term rental laws. And so on April 14th, Mayor Gloria signed that into effect, and it becomes valid July 1st of 2022, so next year. There's no phase in or out period of this. Unfortunately, it's literally just going to be a drop dead date of when this starts. And they're going to create this 4-tier system of license options. So there's going to be tier 1 and tier 2 are going to be home sharing type licenses where you can do it up to a certain number of days per year. And then tier 3 and tier 4 are whole home rentals, which are basically divided up between the Mission Beach district and the non-Mission Beach district. So those were lobbying very, very hard in the Mission Beach district to try to get more licenses for their area. So in the Mission Beach district, they'll be allowed to do a lottery system. So up to 30% of the homes in Mission Beach will be able to obtain a short-term rental license permit. And in the entire city of San Diego that's not in the Mission Beach planning district, they can do up to 1% of all the homes in San Diego. So that's going to mean a lot of people are going to lose out on obtaining these licenses once this goes into effect. And I think there's probably going to be some legal challenges to this if they haven't already filed. And they're also going to prevent hosts from having multiple properties. So if you own, a couple of rentals and you can't basically apply then for a license for both of those. You can only have one host per license per property. So I think we're going to see some family members doing some transfers to be a little creative and change the name and title and things like that. So, Frantz?
Yeah, I think that's probably what's going to happen. One of the questions that I actually did have is that a host has to be an owner, right? It can't be a renter.
Yeah, so what's weird is it defines host as a natural person who has a right to occupy the property or own the property. So that's a little vague to me on how that's defined. I don't know whether that would apply to tenants or not. Theoretically, it could, maybe. I don't know. I think we'll have to wait and see until we get some clarification on that.
Well, because one thing that I know that a lot of people do is they'll, rent it out. An owner will rent it out to somebody who is a property manager, and then that person is going to be essentially be the tenant, and paying them some percentage to short-term rental out the property. So
Yeah, no, I wonder if it's going to actually apply to property management companies or not. I would assume probably not, because especially if they have the one host, one license option, unless the underlying owner is the one that applies for the license. But yeah, I'm not sure about that. That's a really good question.
and also like a property management company, I can just imagine that they would, if it's like one host and it's just a natural person, and the property management company could just like employ 50 people, and those are 50 natural persons, so they get 50 licenses.
Right, right. That's a really good question. I wonder how that's going to be applied. I'm not sure. And of course, like obviously the city still has no clue how they're going to do this lottery system. So, that's going to be a whole crazy shenanigans when that starts rolling out. And who's going to be lining some politicians' pockets in the background to try to get those things passed, So I think there's some of that happening too, maybe.
Yeah.
Well,
I mean, my
go
oh,
ahead.
go ahead. I was going to say, one of my other questions is like, they're doing this by district, I think, right? Or did they change that?
No, so it's for the whole city of San Diego, and the Mission Beach district is the only one that's been carved out.
Oh, it's a city ordinance. Okay, so they had previously what was on the table was it was by district. So now it's just for the whole city of San Diego. So one of the things that they had talked about is like, people who live on the coastal parts of the cities, like, maybe Mission Beach, but also like La Jolla or other, I can't think of other coastal parts, but La Jolla comes to mind. Or like University City or those places, like I imagine that or the gas lamp, like I feel like there's specific areas that are probably going to be more targeted. So people who don't live in those areas might be at a disadvantage for this whole lottery system, because there are just more short-term rentals in, La Jolla and those places than there are in, I don't know, far east San
Yeah,
Diego,
no,
far east in the
absolutely.
city.
Yeah, I think you're spot on. I think a lot of people are going to lose out on this, and it's for many, many people, their investment properties, it's the only way they pay the mortgage. So, that's
Right.
going to be a problem if they can't get the licenses and they can't do the rentals. Then how are they going to make that income to cover what the cost is?
Right.
So, and
Right.
the other thing too is that because you can't transfer the licenses, that's going to make property values far less strong, because if you're trying to sell your property, you can't transfer the license to a new buyer who wants to do the short-term rental. So that's also going to create some issues, I think.
Mhm. Mhm.
So does that mean that there's just going to be there's just going to be a new free license? This honestly feels like what New York City did with cabs at one point. And then they just opened it up to all of the licenses, or anybody who wanted a license could get them, and it completely devalued the cab licenses or whatever. So yeah, there's a part of me that feels like this is going to be a very interesting transitional process for the city of San Diego.
Oh, definitely. I think we're going to see some legal challenges to this before it even goes into effect. So we
For
still have
sure, for sure.
another year to see what's happening.
And guys, if I can jump in here, just to clarify, I know that for the most part, we're talking about, your B&Bs, right? Because that's been like the hottest thing, right? But what's interesting to me is the fact that this is taking effect now as we're coming out of, being sequestered, right? On home arrest almost for the last year. People are getting vaccinated. People are going to start coming out. And so you have so many people that have spent this time renovating their homes, upgrading, repairing, and don't forget the ADUs, right? The accessory dwelling units. I mean, I just kind of came across a couple of people that were putting those up in anticipation of being able to rent out these units in the coming months as everything starts opening up. So, I mean, my gosh, it's like, where do we, stop, take a step back, you know what I mean, and kind of let the dust settle a little bit. And I know at one point, a lot of the surrounding cities were definitely having to go this route because there were so many, right? these Airbnbs popping up and the tenants weren't happy. But now I almost feel like, oh my gosh, people are going to need to generate money. So let's not restrict them immediately.
Right.
Give
No,
them some
absolutely.
time.
Very good point. The one good thing though about this is that if you have like a duplex property where you live in one unit and you rent out the other unit, or you have a granny flat or an ADU and you live in the other unit in the main house or something, those licenses are unlimited. So you can
Nice.
yeah, so those will be in the tier 2 category, and you can rent out that unit, and it's deemed to be home share, even though it's an accessory dwelling unit. And that's my interpretation of the ordinance language.
Okay.
So yeah,
Well,
I
that's good to
had a
know.
client like that asked me that recently. So I think
Nice.
those situations will be sort of carved out of this lottery system. So
Okay, good. Well, then that's a bonus then. We'll
yeah.
take it.
Yeah. All right. So the eviction moratorium, this is very controversial here in San Diego now. This just was enacted on May 4th. So it's hot off the press. And the Board of Supervisors are using their emergency powers to extend the eviction moratorium and make it far more restrictive than what the even state eviction moratorium is in place currently. So it will only apply to residential tenants. So there's nothing about commercial tenants. And it will go into effect June 4th. So just coming up here in like 2 weeks. And it will be in effect until 60 days after the state of emergency is lifted. So that's a very long, potentially time period that this could be in place. And the major issue with this is that no evictions can go forward except for imminent threat to health and safety. So I don't know. I think this is written poorly because there's language in there about notices that have to go, language that has to be in a 60-day notice. And it says, except for non-payment of rent or imminent threat to health and safety, you basically can't get evicted. But it doesn't say anything about the non-payment of rent in the ordinance, really. So I'm not really sure how that's going to play out. And you can only increase rent up to the CPI, which is like less than 2% through July 1st. So the major issue is the fact that you can only evict for imminent threat to health and safety. I mean, that's huge and really detrimental for landlords because they have been going a year now with no rent from these tenants. They have people that are just staying and taking advantage of the situation. They have mortgages to pay. They can't pay their mortgage. They can't pay their property taxes. And now we have this moratorium that went into effect, which has already been challenged immediately by the Southern California Rental Housing Association. They filed suit for an injunction in the district court here in San Diego. So I'm very curious to see if that injunction will be granted and whether this moratorium ordinance is actually constitutional or not. So I don't know. What do you guys think? Thoughts?
I mean, one of my thoughts is, one of my thoughts is that on some level, at least, I feel like it's discouraging banks from foreclosing on properties because if they foreclose on a rental property, then they're going to inherit a tenant who is not paying rent, and they're not going to be able to get rid of them. So on some level, I think that banks are going to be less incentivized to foreclosing, whereas the way the ordinance was before, where you could evict somebody for a, landlord move-in or something like that, then banks might have been willing to foreclose and then try to sell the property, but now they kind of can't do that anymore.
That's an interesting point.
Mhm, mhm. And it
But I
is
am curious
interesting,
how
like you're saying. Oh, sorry, Franz. No, I'm saying though, but it is interesting when you think that yes, they've removed the ability to remove for just cause, which some landlords were trying to use, but of course, many were still very leery about even trying to go that route. And then the easier route, which was moving back onto the property. So removing that ability. And that one is kind of a real questionable one, because what happens if you have an owner that needs to move back onto their property?
Yeah, this basically
No,
says
I
you
mean,
can't do that.
right.
I think that's unconstitutional. So
Yeah. Yeah. So that it's kind of it kind of I don't know. I think that this is a very circular right? A very circular conversation, a very circular debate. And what's interesting is, I mean, let's face it, we know that no one knows how this is going to pan out at the end of the day, right? We're telling landlords there's a fund of money over here which you're going to be able to collect at some point, but they're trying to iron that out.
Right.
We're telling the tenants you will possibly be only liable for 20%. Now let's think about that. 20% of rent that you may not have possibly paid for the last year. So what does that come out to be in the end run, right? And then I think I've heard it mentioned, or I've been reading so much stuff here lately. Franz, you mentioned that where you have the mortgage companies not, maybe so quick to foreclose, but what happens though in those instances where they are at that door saying, well, we need our property back though, because the tenant's not paying the landlord, that might be their only mortgage, they're renting their premises, or they may have two mortgages and they can't pay both of them, right? So something's not getting paid, so everybody here is kind of running around saying, where's my money?
Yeah, exactly.
So it's going to be a tough situation, and I'm just curious to see how this ends up panning out at the end of the day. And and I'm looking at this. You're right, but the state's emergency is supposed to lift at the end of June, and I know that at one point, I know that currently there's no conversation, but there was about a month or so ago conversation about whether or not we need to extend that. So I'm curious to see if they're going to iron out the situation with the money they're trying to give the landlords, or if it's going to be a situation where they're going to say, well, maybe we need to extend it while we still work out the other details, right? Getting further behind. So it is tough. It's tough for everybody. I'm feeling for the landlords. I feel for the tenants. I feel for myself. I'm part of all that group. And, but I don't know. I guess if anything, that adage, misery loves company. So I guess we're all in this together. So it's not like we're going it alone. So
it's literally a full-time job staying on top of these ordinances and changes to the laws in the landlord tenant realm, because I have a property management client, and literally I can't even stay on top of all of it. It's just changing so fast. There's so many new things that keep going into effect, and it's like the notices keep changing, and then this thing changing, and it's like, you can't go forward with the eviction for that reason anymore, so that notice is invalid. So
yeah, and I'll tell you, I sit on some judicial council committees, and because the law is constantly changing, we are constantly having to look at court forms, revamp them, and right when we have them all ready to go, it's like, oh, wait a minute, the law just changed, we need to redo the forms. And so now we're redoing forms specifically in this area of law that will take effect in August, but then who knows, within the next month, we may have to change the forms again.
Right. Exactly.
So
that's if this end too.
I mean, I described it as
whether the state's even going to extend their ordinance too. I mean, that's another question. So.
No, I said that like keeping track of all of these sort of landlord tenant laws in California right now, I said it feels like playing a game of whack-a-mole with an invisible mole and no ballot.
Yeah, that's absolutely a great analogy, because I mean, and even us lawyers can't figure it out, then how is any landlord possibly going to figure this out on their own? There's no way. So
true.
Right.
So true.
Struggle is real.
This might be a really basic question, but if the governor removes his executive order, does that mean that the state of emergency is lifted, or does that mean, or is there another part of that?
I believe that that's what that means once he.
Okay, yeah.
And hopefully that's soon. I mean, given that we're starting to open things up again, everybody's getting vaccinated. Hopefully that means that's going to happen in the, sooner rather than later, but who knows?
I think it'll be before early voting starts in October at the very least.
Which is recall. Yes, indeed.
Yes.
Exactly.
Well, good. All right. So we'll see what happens with this. This is all still pending. I have a feeling these challenges and injunctions might prevail here in county. So we'll see.
Yeah.
All right, we'll let you take it away, Frantz, with our guest interviewee.
Yes, so I have the pleasure of introducing Sonakshi Kapoor. Did I pronounce your name correctly?
That's correct, Franz. That's the right way to say
Okay, thank you. Yes, and so Sonakshi is a litigator up in San Francisco, and you know, we were kind of talking about, well, what can we talk about with Sonakshi? Because I know that she's awesome and she's our CYLA liaison and we see her on the executive committee, but I was like, what does she actually do? So we talked about sort of construction contracts and sort of her practice being focusing on some construction issues with general contractors and breach of contract with general contractors and stuff like that. So what we are going to talk about is critical elements of construction contracts, which there are like massive statutes in the state of California about like what needs to go into a construction contract. And like the statute has specific language and there's typeface requirements and there's like stuff that needs to be bold and it's like, it's ridiculous. So without going into all of those sort of details, Sonakshi is going to talk to us a little bit about, you know, if you are a practitioner or a new practitioner who wants to start drafting construction contracts, one, you should probably get somebody who's really experienced to help you. And two, what are the things that you should really be thinking about in drafting these contracts?
Thank you, Franz. I mean, those are great questions, and I think I think you rightly put it when you say if you're a new practitioner, what you should do, because here I can share my experience of what I've done over the past 2 years. Because when I approached the subject, I was a new practitioner as well, and how I kind of learned the ropes and figured out what are the critical elements and to when we are either drafting a construction contract or even identifying claims in a construction defect litigation. So I mean, I've represented homeowners as well as an organization in a complex construction contract negotiation and homeowners in construction defect litigation. So it kind of bring a perspective of when we're dealing with contractors or architects, project managers, construction managers. That usually happens when it's large or commercial, a large or complex commercial project versus a home improvement project, which is a very different ballgame. So as in when I approached the subject, I definitely did look to the American Institute of Architects, sample drafts on the contracts that are available by the AIA. And they have a very comprehensive list. And that kind of gave me an idea of what kind of work happens in construction projects, how it varies across projects in terms of whether it's a small homeowner whether it's a homeowner who's trying to employ a contractor and subcontractors versus a commercial project where you will have more terms and you'll have more contracts, including with project managers or construction managers, an architect, consultants. You might have a contract for design to buy the design rights of the architect, a contract for sustainability services if that's a requirement in a specific county. So it's definitely the depth of the contract, the depth of the whole project depends on the size of the project, the nature, whether it's commercial or residential, the number of people involved. So these are some important factors to keep in mind. And I did talk about the AIA recommended contracts, and I do think they are good contracts which offer a good overview of what to expect in a construction project, but I do not recommend using them as they are available on the website. You definitely need to adapt these clauses to the specific needs of your client, and also because these contracts are the terms are likely to favor architects. So if you are representing a homeowner or if you're representing a commercial if you're representing an organization or a company in a commercial project, then you want to specifically review each clause and how it fits to the needs of your project, and how you can make it, how you can redraft some of the clauses in a manner that protects your clients. Just touching again on, for instance, when you have a commercial contract, I think I want to emphasize there might be several parties involved. You have contractors, subcontractors. You might have 3 different engineers. There's a structural engineer. There's a civil engineer. You have people who are doing landscaping, and project managers and construction managers. I think along with the contracts that one works on, it's also kind of important to visualize beforehand what's going to be the interrelation between different parties, and possibly even come up with a chain of command, so you can, more, you can articulate more specifically in the contract language, versus trying to figure out later from the contract what is happening and who should be answerable to whom and who is responsible for whom, for what work. So these are few things to keep in mind when approaching construction contracts generally. But also the key provisions that I would look to when approaching a construction contract would be the contract price, the licensing of the contractor, and that the contractor has the required insurance. What is the provision for release of mechanics lien? How is it set up? What about change orders? Do we have a clause that talks about written change orders and how it will be executed? You might also want to pay attention to dispute resolution clauses. The AIA recommends American Arbitration Association for mediation and arbitration. Maybe you do not want that. You want JAMS, or you want some other process to guide the resolution of disputes if and when they arise. So these are the 5 things I would look to when dealing with a construction contract, or even specifically when you're dealing with construction defect litigation, and I will elaborate more. I would definitely first pay attention to whether the contractor has a license, a valid license, and had a valid license during the project, because that is a possible claim against the contractor if the contractor did not have a valid license, because California law clearly states that a contractor who did not have a valid license cannot be paid for the work done during the period when the license was suspended or not valid. Sorry, so just touching back to the contract price, because I feel this is a very important element. But before I begin, Frantz, do you have any specific questions? I'm just going nonstop. Frantz.
Oh, hi. Oh, sorry. I think my internet was like cutting out, and I was going to say that if you're representing, I do know that if you're representing a contractor versus representing a homeowner, that you do have to make sure that the contractor is licensed, because then they're just going to get the equitable value of the project instead of the contract price in litigation, which is really messy to figure out and going to be really expensive for them, or it can be really expensive for the homeowner, depending on what the situation is. But I also think that my internet might be unstable, so
yeah,
I might have interrupted you. I'm sorry.
No, because I know this is an interview and I wanted it to just also give you an opportunity to talk instead of just going on. But I can continue with.
No, that's okay.
Actually, I think you should tell us a little bit about your background, because a lot of people don't know who you are. And I think you have a really cool story about how you got into law and what you do. Absolutely. I think that's the fun bit. So I've been a lawyer in California for about 2 years now. I got my license in 2019. And I started work with my current practice, that's Triano and Byrne, but I'm also now moving into another practice from June 1 with DLA Pipers. So that's the next chapter, but I will give a recap on what I've done so far. I actually went to law school straight after high school in India. I was 18 and I was in law school, and for 5 years, that's what I did. I just studied law, got a degree, started work in India in 2013. I started litigating in Delhi. India, that's the capital.
I did a lot of criminal litigation actually, and I worked with the National Human Rights Commission, working on a lot of cases that the Human Rights Commission would be referred. It's more like an ombudsman versus a judicial system. So they don't have the authority when decisions are taken on those cases. It's not as authoritative as a judicial decision, but it holds value in terms of holding executives accountable in administrative processes. So that was a fun experience. And after that, for 2 years, I worked for a member of parliament in India, a senator equivalent, on some very, very interesting public policy projects. And I think that was one of the most meaningful work I've done. One of the issues that we worked on was decriminalization of homosexuality in India. And I'm happy to say that it's that law has been, the law that criminalized homosexuality has been struck down by the court, and we also introduced a bill in the parliament. So that's one of the most important works I feel I've done in generally.
Amazing.
And
To do something that you make such a big difference with.
yeah, it was definitely a team effort, but this is something that was very, very close to me in terms of I've had just anyway. I also in 2016 I moved to the US. I took the jump to go to UC Berkeley here, and I got my master's in law here. Post which I went back to Asia. I went to Bangkok in Thailand, and I worked with the UN Human Rights Commission and International Labor Organization there. I also ended up clearing the bar. I gave my bar exam before I left, and I ended up clearing the bar exam, but I only came back and then got admitted into the bar. And in 2019, I started work with Triano and Byrne. So that's a whole recap.
You have such an awesome background. I love your story. I think it makes me feel like I haven't accomplished anything in my life.
Yeah, so
I'll tell everyone that you're one of our newest members on the Real Property Executive Committee. So what made you decide to join the committee, and what do you think of it so far?
Absolutely. I think this kind of started because at Triano and Byrne, Mari was a member of the RPLS XCOM. And he kind of brought it up one day that there is an opening for a CYLA liaison in RPLS. Are you interested? And I was like, yes, I am. And thank you for letting me know, because I think this was a great organization to get to know everyone, or get to know other attorneys who are practicing in California in generally. Because I mean, I've only been here 2 years, and I don't have a lot of experience living here, and also my law school was 1 year, so I did not even get to know a lot of people during that time. So I think I thought this was a great opportunity, and I do think this still is, to just know more attorneys who are working here and know what they're doing, and be part of important conversations, which has been the case so far. So I'm very excited, and I'm excited about what's going to come next.
Well, that's awesome. We're happy to have you on the committee. And for anyone who's listening, we have positions that are open still on our executive committee. So hopefully some of you will consider applying. We had a couple of vacancies from executive committee members who had to step down. So there are a couple of shorter term positions that are available. So if you're interested, please email me, and I'm happy to send you the application so you can submit your credentials for consideration. Frantz, did you have any other questions for Sonakshi?
I did not. I really think that what you're saying about construction contracts is actually really important. And as you said, big projects often will usually have lawyers. Everybody will have lawyers involved, and they will do what they need to do and negotiate these contracts. But homeowners, as with COVID, there's a lot of people now who want to renovate their homes or put in ADUs and do all of this stuff. And they actually need lawyers too. So anybody who's like, either a solo practitioner like you, Ashley, or, people who might have like smaller clients, it's actually very helpful for them to just have a lawyer review things and make sure that the contract is at least enforceable so that the contractor understands, look, this is a homeowner who actually kind of knows what they're doing, and they might be less likely to try to pull a fast one than
Yeah.
if you just have no lawyer. So that is actually really valuable information, and
Yeah, I think just to add to
I
that,
think
I
it's
want to
really
make one
important.
important point is for homeowners, it's very important that they have a guaranteed maximum price in their contract. Uh, you could have you could have a clause that kind of lists the cost of the work and plus a certain percentage of the fee of the labor services involved, but definitely have a guaranteed maximum price because you do not want to be slapped with a bill that's 300% more than what the homeowner thought initially it would be. So
Right.
that's very important.
And Shanoski, if I
And
could ask a quick question or ask you to talk a little bit about bonds, because as I understand it, all contractors are they required to carry bonds, or is it just suggested that they have a bond
Uh,
in place?
Well, they are required to have certain insurance and bonds. Specifically, for instance, they're required to have a workers' compensation insurance.
Perfect.
And if they do not have it, if they don't have the workers' compensation for the duration of the project, then the license is deemed suspended for that time. And if a
Okay.
license is suspended, then the contractor cannot claim compensation for the work done during that time.
Okay, perfect. Because, right, if they have their employees coming onto your property doing work, you definitely want to make sure that that workers' comp is in place because you don't want your insurance company having to pick up that bill. And
Yeah.
then even if everything is kosher, sometimes things do happen. And as I understand it, the bond can be sometimes a resource to go to when you have to be reimbursed by the contractor,
Yeah.
correct?
Yeah.
And you can submit a claim against that.
Absolutely.
Okay, that's what I was thinking.
Mhm.
Yeah, I had somebody come in, and I mean, everything that you said to have in place, they had none of it in place.
Oh,
They
well.
wanted to sue their contractor, and all that I had was a piece of paper with the contractor's name on it, 7 line items, which were not clear. It wasn't clear what was going to happen with these 7 items, a price, a date, and a signature. No
Mhm.
completion,
No
due
date of
date.
completion.
Nothing, none of this stuff,
Yeah.
no change orders, nothing about dispute resolution. And that was one of our big issues was, okay, when was this job supposed to be completed?
Yeah.
This is not a contract. What is this?
Yeah.
It was just like an invoice is what it was. And apparently that's how this particular contractor had been dealing with my client.
Wow.
And it was like, talk about pulling your hair out, right? It's like, no, you should have talked to Shanoski first.
Like those
Yeah.
contracts,
Correct.
that you sign on your car,
And I mean, to talk about the seriousness of this, I had clients who were building a custom home somewhere in San Diego, and the contract price was 1.4 million, and I think by the time they finally hired me, they had spent like $4 million.
Wow.
Ouch.
And they were like, and we keep needing more. He keeps asking us for more money. And I'm like, you really should have called me before this point, but
Right.
these are the things we can do.
Oh
Yeah.
gosh.
Absolutely. I
Wow.
think it's a lot of homeowners do not do that also because it's just expensive to have somebody draft your contract.
Yeah.
And there's so many clauses, there's so much information that needs to go in. So I definitely see that as a problem for homeowners to access services prior to entering into a contract with a contractor. And a simple Google search does not help because information is not available. They just don't know what's going on.
True.
I love it when
Yeah.
clients find things online and then they're like, I found this contract online. Can you look this over? And I look at it, I'm like, this is terrible. I need to rewrite it completely. Like, sorry.
Yeah. But honestly, like, I can understand if it's like a $30 or maybe $40,000 kitchen remodel or whatever, maybe they don't want to spend money for a lawyer. But if you're spending like $1.5 million to build a custom oceanfront home, you
Yeah.
probably should cough up like the $3 to $5 grand that it's going to cost to get a lawyer to draft your contract, right?
Totally.
I
'Cause
agree.
you're obviously spending far more than that in all the change orders and everything. So
Exactly.
Yeah.
Yeah, exactly.
And remember though, some of those $30,000 contracts can then turn into $60,000 or $70,000 contracts.
Exactly. Yeah.
So bottom line, definitely, you know, to the extent possible, have your contracts reviewed.
Absolutely. And that's what you don't want. You
Yeah.
don't
And
want to be hit with a bill that's way above what you expected would be.
Exactly.
And there could be like sneaky clauses in the contract that, okay, we will give you guaranteed maximum price, but you might have to bear the cost of the materials and supplies. And what does that mean? Have you decided what material and supplies are beforehand?
Exactly.
So things like
Exactly.
that.
Yep.
great. Well, thank you so much, Sonakshi. We're
so,
happy
Yes,
to have
thank
you
you.
here today.
Absolutely. It was
And
a
you're
pleasure.
welcome to stay on, or you can jump off if you have to go, but we only have a couple more things to talk about today. So
Sounds good. Thank you, Ashley.
thank you.
thank you,
All right.
Sonakshi.
Let's
Yes,
go
thank
over
you.
here. All right, so we have two cases to talk about today, which I thought were somewhat interesting. So we have the Salisbury versus the City of Santa Monica case that was filed in April of this year. And so basically it's a Ninth Circuit Court of Appeals case. And a father owned this mobile home in this mobile home park that's owned by the City of Santa Monica. And his son lived in the mobile home with him. And the father had a lease with the city for placing his mobile home on this lot. The son was never listed on this lease. And so then the father died and the son refused to vacate the mobile home. And he claimed that the city had to accommodate his disability and allowing him to store his vehicle next to the mobile home, which was not usually permitted in this mobile home park. So the city refused the accommodation, and so he sued in federal district court under the Fair Housing Amendments Act of 1988. And the trial court sided with the City of Santa Monica and said that the FHAA didn't apply here because the language of the FHAA doesn't apply to someone who doesn't actually have a lease and doesn't pay rent. And so the Salisbury appealed, and the appellate court agreed with the trial court that Santa Monica was correct in their determination that the Fair Housing Amendments Act did not require landlords to accommodate the disability of an individual if the individual didn't enter into a lease and didn't pay rent in exchange for occupancy. So the FHAA language is actually pretty clear that says it only applies to rentals where there's consideration paid for occupancy. So because this was filed in district court, obviously the federal law was applied and not California law. So I thought that was somewhat interesting. Any thoughts, Pamela or Frantz?
Well, I thought it was interesting that the city had purchased this property or had acquired, right, ownership of the entire lot in 2005. And they allowed this to go on this long. I guess this is kind of, I mean, granted, they did ultimately prevail here. What is this, like 21 years later of going back and forth, not necessarily in court, but just going back and forth with the guy, right? Because they said that the guy tried to get a permit. You know, at one point they ignored them, then they responded. You know, they're going round and round. And it's like, no, sometimes we just cannot, we need to deal with things sooner than later, especially when we're a property owner. So I think that this is kind of one of those one of those cautionary tales where you're just, you know what, don't let it persist. That was one thought I had on it. The other thought is that, yeah, I know they apply the federal law as opposed to California law, but my thought is that my cautionary words rather is for us to remember though too, is that we were also dealing with a governmental entity here, right? And I think that as we're coming out of this COVID era, and there's going to be a lot of suits coming down the pike, I think that landlords are going to still have to be leery about what is deemed a tenant.
Mhm.
You know, so this is not gonna be one of those cases where you're gonna be able to say, because you know how, you know, the deal, sometimes, you know, there'll be a person that's in a home and then they have friends, family members, a whole bunch of other people in the home, right? And they're trying to evict everybody, right? So they're going to be really careful in the sense that they think that this case might give them some relief, because it's not going to happen, I don't think.
Right.
That's my thought on that.
Right. Yeah. I mean, I don't think I don't know. I'm not as familiar. I haven't read the California Fair Employment Housing Administration Act, but I'm assuming it probably has similar language that would apply to tenants that pay rent and not squatters, for example. So, because I mean, landlords are required to do the reasonable accommodation for disabilities for tenants. So, I think it would probably be the same outcome with a California case, but I don't know that for sure.
Wait, I'm sorry. Let me
Yeah,
clarify. I was clarifying. I'm sorry, Ashley. You're right. As far as the accommodations part, they are going to come down the same. I guess my mind, I'm just still stuck in my eviction mode for everything else. Okay. And I'm like, people, just be careful, you know, yes.
Well,
Because
yeah, I mean,
evicting for other reasons.
yeah, they would have to evict him. I mean, the son's been there for years, even though he's not on the lease and not paying rent, he still has tenancy rights essentially and has to be evicted. So
Exactly.
yeah.
And that's probably why the city sold the property to a private. No, I don't know.
Probably. Okay, and
yeah.
then the
I mean,
last,
I was really curious.
sorry,
Oh
go
no,
ahead.
I was going to say I was really curious about the forum shopping and the choice to go to federal court instead of state court, because just thinking about it, I think that California law would be more likely to be interpreted in favor of the tenant, regardless of whether it would be, than federal law. So I just wonder why they made that decision, or why his attorneys made the decision to sue in federal district court. And I was thinking like maybe there was some sort of statute of limitations or some other thing that was going on that prevented suit in state court.
Yeah, I don't know. I don't do litigation, so I'm not sure why that choice was made. If there, maybe it's like attorney's fees clauses or something. I don't know. I'm not sure. So.
Good question.
All right, and then the last case to talk about today is Gill versus Winn-Dixie. This one is not specifically real estate related, but I thought it was interesting just because we have a conflict between the Ninth Circuit and the 11th Circuit Court of Appeals. So Winn-Dixie store had a website and they were sued for claiming there was a violation of the ADA for individuals that had visual impairments. So the 11th Circuit actually disagreed with the district court's ruling and said that Title III's application is limited to physical spaces and not intangible spaces like websites. So they rejected the claim that Winn-Dixie's inaccessible website served as an intangible barrier to Winn-Dixie's goods and services because there were no goods or services available for purchase on the website. So all transactions had to be completed in store. The website was really just for perusing things, but not for purchasing. So they didn't hold that the Title III ADA rules applied to this website, which is pretty much, well, I guess it's not a direct conflict, but it definitely is a little bit opposite of what the Ninth Circuit held on that famous Robles versus Domino's case that was pretty recent, where Domino's was sued for claiming their website was inaccessible, but in the Domino's case, you actually could make purchases on the website. So there was a big difference there between having it be accessible or inaccessible based on goods or services being purchased. So I thought that was interesting. Obviously, these are two different decisions from two different courts. So we don't really have a final determination on these ADA website lawsuits, but I think we will probably see more of these being filed in the future. Any thoughts?
I mean, I think in terms of real estate, I was going to say, I think in terms of real estate, this is actually a really interesting question if I'm thinking of like real estate agents and brokers, because technically they don't have goods or services for sale on their website. Like you can't buy a house on the website, but they do have a display of the goods and services that are available for purchase in other through that broker. So this seems to like sit in the middle of, or broker websites seem to sit in the middle of these two cases of like there are goods and services kind of available for purchase, but they're not really tangible and available for purchase in the same way. So this might be a really good place to settle this law and be like, okay, well, what does this actually mean?
Yeah, I think so. It's this website ADA stuff is really fascinating to me, and I definitely know I've spent a lot of money with my web team to make sure that my website is ADA compliant, even though I don't offer goods or services for sale on there.
Mhm. Yeah, that's what I was just thinking about that. Ashley, I'm like, I'm in the process of uh, doing something with a website. I'm like, oh my gosh, maybe I don't want to do this anymore.
Yeah, yeah.
You
Well,
know,
I mean, the violations are pretty hefty fines. So if someone sues
yes,
for that, you know, it's a big deal.
yeah. And you know, we're in an age, right, where we're doing so much now virtually. So
Yep.
so then what happens? What happens when you are providing your services only um, through the internet, right?
Right.
And then and so then I think that that opens up a whole new um, area of concern. You know, no, one thing that I do that Franz knows is I do legal clinics, right? And so a lot of legal, not even just mine, but a lot of legal clinics have transitioned to being done virtually. So then what happens? I mean, we've had our challenges. We'll have people coming in and we're having to navigate them just from the perspective of having to navigate, right? This type of medium. But then what happens when you have someone who is like visually impaired, right? Or maybe, you know, has a hearing, they can't hear, or they need a hearing aid, then what happens? So I don't know, this has opened up a whole new area of inquiry and for myself, making me want to look at the different things that I'm participating in to see if these are areas in which there may be new rules, regulations, what have you, that will be coming down the pike. Because I'll tell you, my thought is, my 2 cents worth is that this way of doing business most likely will not go away. You know, we're enjoying it. It's made things a little bit easier, right? And so I don't see this as being a medium that we're going to be so quick to want to give up. But along with that, I'm sure there will be more rules and regulations. So thank
Yep.
you. Thank you for heightening my level of interest and concern here.
I'm scared now. Great.
Yeah.
Not my.
And fun fact, now Winn-Dixie actually does offer goods and services on its website because you can buy online and get stuff delivered. So I wonder if they've updated the ADA compliance issues.
Probably. I mean, this case was probably filed before COVID, and obviously the appeal only came down recently, but yeah, it's interesting stuff. All right, and then now we have our upcoming activities. So June is a huge busy month for the real property section. We have all these lovely seminars coming up. We have lease workouts in the age of COVID on June 1st. We have assignment and subletting tips on June 8th. Commercial lease guarantees by foreign entities on June 10th. Hands off my public contract on June 17th. When adversaries are friends, that's a replay, but a really great seminar if you haven't seen it. And that's got ethics credits on June 22nd. Top 10 issues that arise in partitions cases on June 24th, and a construction law update on June 28th. And then down the pipeline, we have the summer cannabis series, which is going to be June 3rd, July 1st, and August 5th. The women in leasing is also coming up. That's the lease workouts in the age of COVID. That's the first leg of the women in leasing series. And the Crocker Commercial Symposium in September. And if you want to contribute to the e-news, the journal, webinars, we would love to hear from you. We hope you will all contribute. If you're interested in joining the real property law section, let us know. The executive committee. Am I forgetting anything, Franz?
No, I don't think so. I think we're doing a yoga thing, right? But I don't remember
We
when.
haven't set a date for that yet, so that's TBD.
Okay.
Yep. And then our
Yeah.
next, oh, sorry, I thought I updated that, but the next one is June 17th at 12:30. So as Neil would say, be there or be square. So thank you so much, Pam, for joining us today and being on our panel. And thank you, Franz, as always. And it looks like we are done a few minutes early today. So we will let everybody go. But thank you so much for being here.
Hey, thank you guys. It was
Thank
fun. I
you.
enjoyed it.
Bye. It was fun. Bye bye.